Welcome to our panel. So I'm Matteo Beretta from Cleary Gottlieb, together with my two colleagues from the Milan office, Riccardo Tremolada and Laura Tresoldi. And we have a guest, Salvatore Branca, who is Associate General Counsel responsible for corporate finance and acquisitions legal affairs at SNAM SPA. So a company, an Italian-based company active in the natural gas transmission industry. So we are here today to talk about a very important landmark judgment adopted by the European Court of Justice a few weeks ago, on September the 3rd, in the Lumina Grail case. One of probably the most important judgments rendered during Commissioner Vestager's 10-year mandate, and probably one of the most relevant judgments rendered by the court in the last 30 years in the area of EU merger control. I will start with an introduction on the background of this case, on the Lumina Grail transaction, and on the key findings of the European Court of Justice. So let me start with the relevant provision at stake. So a little known and rarely used provision contained in the European Union Merger Control Regulation, Article 22. It is one of the provisions providing for the possibility for a referral from the national state level up to the Commission. There are also referral mechanisms which go in the opposite direction from the Commission to member state. But this provision in particular basically says that one or more member states may request the Commission to examine a merger which has no community dimension, that affects trade between member states and threatens to significantly affect competition within the territory of the member state or states making the request. So this is the provision at stake. So, following slide. What is the key substantive issue at stake here? So we are basically talking about so-called killer acquisitions in the spotlight. In recent years, there have been a huge debate at the European Union level, but also at the national level, concerning the perceived need to capture under merger control rules mergers which involve parties whose turnover is so low that basically the transaction cannot be reviewed by the Commission or by national states. So basically we are talking about transactions involving targets whose potential competitive impact on the market is not reflected by the turnover. There are targets which can be very innovative in the market, mainly in the digital and pharma industries, which have zero turnover. Grail is one of those examples. Grail in Europe had zero turnover. But still, these are transactions which should deserve probably merger control scrutiny. And so this is the central column. There are so-called killer acquisitions or acquisitions which are perceived to be potentially such, so killer acquisitions, which escape merger control scrutiny. The column on the left, Article 22, so we have seen there is a potential for referral from the national level to the European dimension. But this provision has been was aimed and has been conceived since the onset as a provision aimed to remedy the absence of national merger control system at the national level. And this was clearly so in 1989 when the EU merger regulation was adopted. The regulation entered into force the following year. And it was the Dutch clause, because the Netherlands was one of the few merger control states which at that time had no national merger control regime. So they wanted the possibility to refer a case to the Commission absent domestic merger control regime. Of course, we have seen that Article 22 provides for the possibility to refer a case from the national level to the European Commission, but the European Commission has systematically discouraged Article 22 referral requests from member states that did not have jurisdiction, so that did have national merger control regimes, but were facing mergers which were below national threshold. So the Commission's position was very clear. And importantly, Article 22, in the meantime, so as from 1989, became an obsolete provision because almost all member states in the meantime have adopted merger control laws. Now the only member state at the EU level which has no merger control regime is Luxembourg, but maybe things may change in the near future also for Luxembourg. So what would be the option to cope with the need to review below the threshold but potentially problematic mergers? So clearly one option was to amend the European Union merger control regulation by lowering the thresholds or modifying the thresholds, so to capture more mergers that are potentially problematic. But this was an option not chosen by the Commission, mainly because they did not want to open a debate before the Council, which is the political institution with jurisdiction to review the European Union merger regulation, because during this revision process, probably other stakeholders, including some member states, Germany, France, could have pushed for a revision of the substantive rules of the regulation, possibly making them more flexible to allow the creation of national European champions. So this was the Commission. This was something the Commission wanted to avoid. Although, following the Draghi report, maybe we can expect that this revision to take place in any event. So this was one option, not followed by the Commission, because in 2021, the Commission adopted a guidance paper which basically contains two key messages. The first one, the Commission says, contrary to what happened in the past, that Article 22 is applicable to all concentrations, so not only to those that meet the respective jurisdictional criteria of the referring member states. So also member states which have a merger control regime at the national level, in case of below the threshold mergers, can refer the transaction to the Commission. And the second message is the Commission encourages member states to do so. This is exactly what happened in the Illumina Grail case. Okay. The turning point. So, interestingly, Illumina is a vertical merger. So it is not a merger between competitors. It is a vertical merger, possibly a merger which was expected to be a game changer in the fight against cancer. So a very important pharma industry and a potentially very important merger. Illumina Grail were in the past already part of the same group. Then they split. And so this transaction was again back to the vertical integration. In the US, the FTC failed to persuade the administrative judge to pursue the case, but in Europe, the Commission obtained jurisdiction following a request for referral by the French authority, which was joined by other national competition authorities. So basically, the deal was announced in September 2020, and in April 19, 2021, the Commission adopts the famous Article 22 decision in the Illumina Grail case, which is the decision which was appealed by Illumina and by Grail, and which resulted in the judgment we are discussing today. I forgot to mention that in the meantime, following and in parallel to the adoption of the 2021 guidance notice, a number of member states amended their national merger control regimes, introducing, for example, transaction size thresholds, Austria and Germany, or below the threshold rules, for example, Italy, so allowing the national competition authority to acquire jurisdiction over a case which was previously below the thresholds. No, sorry, we are still, we're still here. Okay, now we can go ahead. So Illumina and Grail file an appeal. They lose in the first instance because the General Court dismisses the appeal. But the decision of the General Court is appealed by both Illumina and Grail. And the key takeaway from the judgment of the Court of Justice is that a member state with domestic merger control rules cannot seek an Article 22 referral if the transaction is below the national thresholds. So again, back to the original interpretation of Article 22. The decision is highly structured, very complex, very sophisticated, but still very interesting. So, literal interpretation, even where a provision like Article 22 appears to be clear, there is still room for historical, contextual, and teleological interpretation. So, historical interpretation, Article 22 legislative history contradicts the General Court judgment. Article 22 was clearly enacted to address the absence of national merger control regimes, Dutch clause, and not the fact that certain concentrations could affect the internal market and still could escape merger control scrutiny. So it was not a corrective mechanism. Contextual interpretation, if the Commission realizes that there are too many mergers potentially harmful for competition, the option is to amend the European Union merger control regulation. There are clear provision, Article 1, paragraph 4 and 5, which allows a rapid adjustment of the thresholds. So this is the main avenue. Teleological interpretation, a broad interpretation of Article 22 is inconsistent with the guiding principles governing the European Union merger regulation, which are legal certainty, effectiveness, and predictability. There is also clear need for a clear system of allocation of competencies between national competition authorities and the European Commission. And the alternative tool, absent a revision of the European merger control regulation, is to apply Article 102. So the recent Towercast judgment clearly points to this conclusion. So, what are the case-specific implications? Of course, the judgment has a clear, huge systemic implication, because now the Commission has to do something different with respect to what they've done so far. By the way, I forgot to mention that pending the Illumina Grail procedures, other 3 below the thresholds mergers were referred to the Commission, even if national merger control thresholds were not met. But these 3 mergers were not pursued by the Commission because they were abandoned. So we worked on the Illumina Grail case. I was not one of the lawyers representing Illumina, but Cleary Gottlieb did. And so when we announced to our clients this huge victory, some of them replied, well, congratulations, but this is a Pyrrhic victory, because in the meantime, Illumina already divested Grail. So still, there is some value for this decision. First of all, because it invalidates all the decisions that in parallel the European Commission adopted in connection with this merger, including, in particular, the gun jumping decision, which fined Illumina and Grail, but mainly Illumina, with at the time a record fine of 423 million. This is invalidated. And then it leaves the door open also for the possibility to ask for damages, although this is a decision which Illumina has not taken yet. Still, the legal test is very strict, but the possible damages are, in theory, very, very significant. I leave the floor now to my colleague Riccardo, which will talk about the implications of the Illumina Grail judgment.
I'll stand up as well. So thanks. I'll pick up on what you were saying. I'll go through the main implication of the judgment. So we can flick through. Yeah, so the very first implication, probably the most consequential one, is that in this post-Illumina world, any transaction that falls below EU threshold and that is not captured by national merger control rules will no longer be subject to merger control in the EU. And that applies to both horizontal killer acquisition as well as vertical ones, such as the Illumina Grail deal that Matteo was illustrating. This is a fundamental change for us, for clients, especially in times where investors and their transactions are ever more subject to tight regulatory scrutiny. And that's not just for merger control reasons, but because of the application of foreign direct investment regime, as well as the newly adopted earlier last year, the foreign subsidies regulation. So as I said, this is a key development. You have to think that right now member states are no longer allowed to use Article 22 to refer a case to the Commission unless they do have the power to review the referred deals, or of course in the rare case where they do not have any merger control system in place. But as Matteo was saying, that's just the case of Luxembourg right now. And by the way, Luxembourg is also discussing to introduce a new merger control regime. So we're going to have basically all 27 states with merger controls. There seems to be a misconception out there that the Commission post-Illumina has got somehow its wings clipped. I don't think that's the case. I don't think that we will see a softer enforcement. If you look at the reaction of the Commission in the wake of the Illumina decision, you'll see that there is a strong continued will to tackle below threshold transactions, and especially in sectors such as biosciences, biotech, life sciences in general, and digital tech, pharma, of course. All these sectors where historic revenues do not necessarily reflect the value of the target companies, the potential value of the target companies. I think that this strong will of the Commission to keep tackling below threshold transaction also emerges by reading the mission letter that the EC President von der Leyen sent to the new competition commissioner, Teresa Ribera, entrusting Ribera to find ways of closing this perceived enforcement gap. So where does that leave us? I think that right now the Commission has at least 3 possible routes that they could use and pivot in order to keep reviewing below threshold transactions. Before we dive into them, I think it's important to stress that they all come with limitation, and that's probably a function of the fact that none of these options places the Commission in the driving seat. So we can go to the next slide. So the very first option, of course, is amend the merger regulation. As Matteo was saying, the merger regulation itself provides for a simplified procedure enabling the Council, on a proposal by the Commission, to modify the notification thresholds and therefore to redefine the scope of the merger regulation. Of course, reopening the text of the merger regulation might leads to some horse trading on highly sensitive topics such as sustainability, industrial policy, or global trade. And these are all topics where the interest of the Commission and the interest of the member state might not necessarily align. And that's probably the reason, as Matteo was saying, why the Commission decided in the first place to advocate for an unlawful interpretation of Article 22 in Illumina rather than engaging and seeking to amend the merger regulation in the first place. So on the merits, as to what changes can be proposed, I think that there are 3 main options on the table. The first one would be lowering the notification thresholds. Of course, that comes with the risk that the Commission will need to face an increase in administrative burden. The second option is introducing value-based thresholds. That's already the case in some of the countries, Germany and Austria, for example. And the third option that was floated by Executive Vice President Vestager just a couple of weeks ago, right after the Illumina judgment was published, would be to introduce a new standalone power to call in particularly problematic below national threshold transactions. That would be the most problematic of the 3 options that I just listed, probably because it assumes some balance in terms of legal certainty, and that was, of course, the #1 issue that we litigated in Illumina. So the second option would be to rely on Article 22 referral requests by member states who do have the competence, the jurisdiction to review below national threshold transactions. So what does competence mean in this case? So as you know, some member state has already introduced alternative thresholds, alternative to turnover. That means value-based, as I said before, but also market share. That's the case in Spain. But as my colleague Lara will explain, the most important development is probably that a number of states, including Italy, have adopted calling powers. So I think that at this time it's hard to say where this trend will go. There are, though, a number of limitations to relying on member states using their calling power. I think that it would be naive to consider that relying on national competition authorities' calling power would allow the Commission to keep reviewing killer acquisition post-Illumina. And that's for a number of reasons. First of all, it's not that these calling powers do apply to any deals around the world. They come with a lot of constraints, a lot of alternative set must be met. Usually it's local nexus, but even if it's not local nexus like the Italian law, you still have to demonstrate a prima facie competitive risk in the national market. So as you see, the burden is pretty high. And the more fundamental limitation, I think, that goes back to the fact that relying on calling power might be perceived as basically a workaround to EU rules, basically a backdoor allowing the Commission to keep reviewing killer acquisition using Article 22 in a way that was not intended by the legislator. And that could, of course, lead to more Illumina-like litigation. The third option would be to rely on ex post review of below threshold transaction based on Article 101 and 102. That's in line with the Tower Cast judgment, of course. As you know, the ECJ in March 23 said that all transactions, even if they fall below EU or national merger controls, can be reviewed under Article 101 and 102, even after they've closed. It's hard to predict now how this trend will go on, I think, but it's important to flag that, for example, the Director General of the DG Comp, Olivier Gerson, flagged that this could be a viable option for the Commission in case the ECJ decided to overturn the application, the interpretation of Article 22 proposed by the Commission in Illumina, which the ECJ did. So we'll see where we'll go with that. Olivier Gerson himself, though, admitted that this option is quote-unquote messier, and I tend to agree with him. There are a number of limitations that comes with an application of Article 102. First of all, you would have to have a transaction involving dominant position. Companies that already have a dominant position at the time that the transaction takes place. So that's likely to apply to a very limited subset of cases. The second limit, it's probably linked to the fact that there is a high burden for national competition authorities. Article 102 requires the national competition authorities to provide an analysis of the effect of the conduct, as well as to establish a causal link between the transaction and the harm to competition. Again, that's a really high burden for any national competition authority. And probably one of the major limitations to applying the Tower Cast case law to below threshold transaction is linked to remedies. So as you know, Tower Cast law case says that you can assess under Article 102 a transaction with no time limit. So there's no such a thing like a 6 months limit. You could assess it even a year after the transaction has closed. And as you can tell, it's going to be very hard for a national competition authority to unwind a transaction that's been already implemented. So a lot of questions, but yeah, conscious of time, I'll leave it to yeah, I'm not going to touch on the DMA. I'll leave it to Laura.
Okay. We will now move on to the immediate reaction that the Illumina judgment prompted by national enforcers. And first of all, the Illumina Grail judgment had indirect implications for another case which was referred to the Commission under Article 22. So basically, this is the Microsoft inflection case, and 7 member states refer the case to the Commission, but then, following the Illumina Great judgment, they decided to withdraw their referral request to the Commission, and so the Commission will no longer decide over this matter. In addition, member states also commented on the Illumina Grail judgment and said about their future plans on below merger threshold. And I grouped them in two main categories. First of all, the Belgian, Danish, Austrian and German authority said that they do not see the necessity to introduce new calling powers for below threshold mergers for different reasons. First of all, the officials of the Belgian authority said that they will continue to apply their specific approach to below threshold mergers under Article 102, so following the Towercast judgment. The Danish authority said, no, we will not introduce other calling power, and we will rely on our current below threshold regime. And then we have the peculiar regimes introduced a few years ago by the German and Austrian authorities, which introduced as Matteo said, transaction value threshold, which allow both authorities to catch a small target, but when the consideration is large. Another group of authority said, maybe this new judgment and new approach to Article 22 may be an additional argument to introduce new calling powers in our national regimes. And this is the case of France. So in France, there is no regime for below threshold mergers yet, but the officials of the French agency said we will continue to use their existing powers, meaning Article 101 and 102, but they are also considering to strengthen a national instrument in order to catch also other mergers which do not meet turnover threshold. The Dutch authority basically said the same, so this is an additional argument, and we will discuss internally if we need to tweak our merger control regime. Next slide. So what is going on in the member state? This is a map of the current below threshold merger regimes throughout Europe. And as you can see, there are 12 member states which currently have in place a below threshold merger. Some of them, which are colored in red, have the so-called hybrid calling powers, meaning that these regimes combine turnover thresholds or market share thresholds, for example, in Lithuania and in Latvia, with a more discretionary threshold, which of course put legal certainty at risk. Then we have, as already said, two member states, Germany and Austria, with deal value threshold. And finally, we have the member state colored in green, which have merger control regimes just based on the discretionary rules. And finally, there are some minor member states where discussions on the below threshold mergers is ongoing. Focusing on Italy. So in Italy, as said, we have hybrid calling powers which combine turnover threshold, and this criterion based on concrete risk to competition. The application of this criterion raised a number of issues, as this is rather vague and make it complex for companies to understand when the Italian Competition Authority will call in a specific merger. And Salvatore then will discuss this further. The Italian Competition Authority tried to explain more clearly how this concrete risk to competition criterion should be interpreted, and released a notice on February 2024, which explained the factors which create concrete risk to competition. And by way of example, market structure, the total value of the transaction, and the nature of the activity of the parties involved in the merger. As you can see, the market on which the Italian competition authorities open a review process for a below threshold mergers are basically traditional local markets, which goes in a different direction from the original aim, which was to tackle killers acquisitions. Next slide. And these are the statistics on the current below threshold merger before the Italian Competition Authority. As you can see, the Italian authority opened just 8 procedures for below threshold mergers. 5 of them were based on a voluntary communication by the parties, and the other 3 were open upon complaints by third parties. Just 1 of them was notified post-closing, and the final decision was released for 3 of them in phase 2. On the length of the proceeding, on an average, the length of the proceeding is about 2 months and a half, and in phase 1 is 1 month and some days, and in phase 2 around 5 months. We'll leave the floor to Salvatore.
Hello everyone. First of all, I would like to start by thanking Matteo Beretta and the Cleary Gottlieb team for inviting me today. It's really a pleasure and an honor. When they invited me, I tried to imagine which kind of contribution, which kind of perspective can I give, can I bring as in-house counsel to a discussion amongst antitrust experts on such interesting but at the same time challenging topics on the below threshold merger reviews in Europe, and in general the recent development introduced after the Luminal Grail case and under the recent inaction of the Italian law on this topic. I believe it could be valuable to share with you which could be the practical implication of these recent trends, recent development for a company like Snam, in the case Attend, and specifically how the companies can react to this development and which could be the possible way forward. So I'll try in the next 10 minutes to walk you through this topic. First of all, I would like to stress how important is a legal and regulatory risk assessment for a company when approaching a potential M&A transaction. Basically, when a company is looking at a strategic asset, at a strategic joint venture, the first question to answer is, can I do it? Answering this question implies an economic and financial evaluation in terms of price to be paid, how to finance such price, which is the IRR of the investment, but at the same time, answering this question implies making a legal regulatory assessment to identify and prevent any issue that may delay, prevent, or affect in general a certain M&A transaction. For example, according to Snam internal policies, this is something we are required to do since the very beginning of any project. I mean, before submitting any non-binding offer for any acquisition, before presenting any M&A project to our corporate bodies, we are required to do that. This is probably mainly due to the fact that Snam is a listed company, is subject to a strict regulatory framework, to an unbundling regime. It manages mainly strategic assets, but I'm quite sure, and I can confirm, that this is quite common to all the companies of a certain size. Furthermore, based on my experience on M&A transaction, and specifically on M&A, so-called bidding process, competitive sale process, the trend demonstrates how sellers take care of this risk, and therefore usually require buyers to submit, since the beginning, since the submission of binding offer, a regulatory and legal assessment of any FDI, foreign direct investment, or antitrust filing, or other regulatory filing required in connection with the transaction, including an estimation of the timing, of the potential issues of that filing. So let's say in this challenging M&A context, the discretionary standard, the non-objective standard introduced at the European level expose the company to a significant degree of legal uncertainty, expose the company to cost in terms of making the assessment and making a prognostic analysis, which is quite unpredictable and can expose the company at risk toward the counterparties, risk toward the authorities, risk toward the internal stakeholder. Another issue, in my view, is represented by the fact that the authorities may carry out an ex post review. This, as you can imagine, for a company, it could be really an issue because, in case the transaction is prohibited or in case certain conditions are imposed after completion, this exposes the company to reputational, economic, and financial risk. Coming to the next slide, please. Now, I want to share with you which could be, in my view, the approach, how the company can react to this legal uncertainty. In my view, there could be basically two approaches. One is a prudent approach, which means being transparent toward the counterparty, being transparent toward the authorities and the internal stakeholder, therefore making a voluntary notification where a company is approaching an M&A transaction which potentially trigger the non-discretionary standard of a below-threshold regime. Which could be the upside and downside of this approach? Of course, this reduces the risk for the company towards the regulatory authorities, toward the counterparties, toward the internal stakeholder, but it reduces the risk of ex post review. And at the same time, the downside stay first in the fact that there could be an increase in the cost for the company and the risk, the assessment to be made by the company. But at the same time, I mentioned before the competitive sale process. Such approach would probably reduce the attractiveness of the offer to the seller compared to another offer which excludes any regulatory implication, any regulatory filing. At the same time, from a contractual perspective, such approach could expose the buyer to accept burdensome provision in the relevant SPA, such as the so-called hell or high water clause, which basically expose the buyer and oblige the buyer to accept any condition imposed by the authority and to go any way at completion in any case. Or, for example, to break a fee in case the deal is not completed for any reason whatsoever, unless, of course, the seller is in breach. Or taking fee mechanism, which basically remunerate the seller for the period between signing, or in some case, when there is a lockbox mechanism, between a certain reference date and closing. An alternative approach could be a risk-taking approach. Basically, it's the opposite of what I said, and even the pros and cons are the opposite, so I will not repeat them. Maybe what we could stress here as the main downside is that this exposes the company to the risk of an ex post review, which means that the company will face a situation, even remote, but there could be, that the deal needs to be unwound, or the company needs to accept certain conditions in a situation where there are no contractual remedies, because usually in an SPA it's very uncommon and very difficult to negotiate the so-called conditions subsequent that allow the buyer to terminate the deal after closing. So next slide, please, Riccardo. Which are the broader consequences of this regulatory legal uncertainty situation? So in my view, we may assist in the next year to an increase in the number of voluntary notification. Like, for example, what happened in connection with the pre-notification introduced in Italy in connection with the Golden Power regulation. This is because, I mean, as in-house counsel, if my company were to be in a situation where there could be an M&A transaction that could trigger a below-threshold merger, I will strongly recommend my top management to proceed with the voluntary notification. I mean, which could be the consequence of that, that even the authorities will need to suffer additional burden in order to reply in a certain and short time frame to this voluntary notification. And in this respect, I mean, the European regulation does not seem to provide a certain and short time frame by which DG Comp should reply to this voluntary notification. And even the 60 days term provision included in the Italian law does not seem to be, I mean, to comply, to meet the need of a fast-moving environment such as the M&A environment. The second risk that I see is that there could be an increase in the number of opportunistic complaint by third party, by competitors whose main purpose is to hinder a transaction made by another competitor. In this respect, it could be appropriate that the antitrust authorities make a preliminary investigation on whether, I mean, the third-party complaint is well substantiated, and maybe we should also evaluate whether to introduce some fines, some penalty for third-party complaints which are manifestly ungrounded. The third and main consequence which I see is that this situation may discourage investment, especially certain kind of investment by certain kind of company, especially industrial company. So horizontal and vertical merger might be penalized in favor of speculative investment, even if these transactions, so this horizontal and vertical merger, may generate benefit for the system, pro-competitive effect for the system, and may become virtuous investment, for example, in terms of synergy, cost reduction, innovation, sustainability. And this situation does not seem to be in line with the recent target on the European Commission industrial policy agenda, which, as already Matteo mentioned before, aim at favoring the growth, the competition of the European companies in order to become the so-called national or European industrial champion. Next slide, and I will conclude. I mean, in conclusion, the three main implications of these developments stays basically in the fact that they generate legal uncertainty for the company, generate risk and cost for companies. This translates also in risk and cost for the European authorities that need to have the capability to respond to this voluntary notification, to this third-party complaint. As I just said, this development may have a negative impact and may discourage investment capable to generate positive effect for the system, and therefore which could be the way forward in my view. I mean, the first one is to coordinate this development, this trend, with the target of the industrial the European industrial policy, especially in terms, as Matteo mentioned the Draghi report before. I mean, and the main recommendation in this respect are to reduce the regulatory burden for the company, allow the growth of European companies, especially in sector open to innovation, such as digital, green energy, pharma, accelerate the decision-making project and ensure the predictability of that project, and in general, eliminate any uncertainty on whether a transaction could be subject to a merger control review and by which authority. So an alternative solution, which was already introduced also by Riccardo before, could be there to lower the objective threshold instead of introducing non-objective threshold. And the last comment I will make is that the ex-post review should be and should continue to be the exception rather than the rule. So even the ex-post review under Article 102 should remain limited to the case where there is a a clear evidence of a market power exploitation arising from the merger, and not should be, I mean, the application of this article should not be broadened, let's say. Let me conclude by saying that, I mean, I really hope that the recent nomination by President von der Leyen of Teresa Ribera Rodriguez, which was also mentioned by Riccardo before, could, with a clear mandate, yes, to address the risk of killer acquisition, but at the same time to modernize the competition policies in Europe and to allow the company to grow and compete on a worldwide level. So I hope that this, in case the nomination is confirmed, of course, may help to solve these practical implication and may restore, let's say, the legal certainty and predictability of the merger control review process in Europe. Thank you all.
So, Alan Riley, College of Europe. One of my observations about this process is that if you look at the Advocate General's opinion in Lumina, obviously everyone focuses on the kind of kitchen sink approach he took to destroying the position of the General Court and the Commission, which was kind of very detailed and exhaustive, and in fact, to some degree, quite funny. But the other point, which I think it illustrates, is when he talks about the difficulties of transparency, predictability, and legal certainty, they're not just in relation to having a guidance note, which the Commission has published, but it applies to any process under which we have these call-in powers for very small entities. And there are a whole host of issues in terms of what on earth do you do in relation to closing. I mean, there has to be some point when a deal is a deal, it's closed and it's certain. You can't have these things hanging out for years. How do you deal with that? You know, what is actually our criteria we're trying to apply? And none of those things, I think, are immediately obvious. We have got relatively little experience with this. So I'm just putting out one idea. I was trying to work out what solution might work. Is part of the solution is that what we should look at is, okay, some member states may want to use their call-in powers and value threshold powers, and perhaps they should be encouraged to do so for those who have already are in that direction. But the European Competition Network could try and create a common guidance which would provide some degree of predictability and transparency, so we could build up a practice so we know what we're doing. Because I think there's a significant degree, when you look at this element of the Advocate General's opinion, it's clearer than in the judgment, that we actually have some real problems here, whichever position you take on this issue, which have to be addressed. And that's my observation on this.
This was a question or your, but I like very much what you said. I think if you look at the last pages of the judgment, it is clear that the court says that when it comes to European merger control rules, there are some guiding principles which are predictability, effectiveness, and clear allocation of tasks among European member states and the European Commission, so the interinstitutional balance. I think the message there is to the EU institutions to review the European merger regulation in a way that could capture more potentially problematic mergers. Then what you say about the need also to have a more institutionalized system of cooperation with more clear rules regarding the way national institutions apply their national regimes is also another welcome development. I think the key message to the institutions is to review the European merger control regulation.
Very direct and simple question concerning the interpretation of tower cost, because you are suggesting that both national competition authorities and the European Commission can apply 102 ex post to mergers, whereas this is not the, literally the content of the judgment, and I know, I cannot tell you why, but later on, that the DG Comp is a little bit reluctant to interpret the judgment as clarifying that they have the power to intervene.
No, it's a fair point. The judgment doesn't say that the European Commission can apply, indeed. I think it comes down to what Matteo was saying on interinstitutional coordination, to the extent that we agree that this is just a power for the national competition authority, there is a huge risk of diverging outcomes and inconsistency. So I agree with you. In a perfect world, we would have to have either some sort of coordination or the European Commission stepping in and reading, maybe stretching the Tower Cast judgment and trying to sort of derive some power for the Commission to apply 102. I think it's still up in the air, but yeah, it's a fair point.
Hello, this is Christoph Raab from Bindergrößung in Vienna. So thank you very much for also including the perspective of the Austrian Competition Authority. And I want to elaborate on that because I think it's very important for the general understanding of the approach, because Austria, despite being quite a small member state, as I'm sure much of you who work in merger control know, has quite low thresholds, and we have a lot of cases. And what they basically also said in that statement that you probably cited from LinkedIn, that their previous referrals were only based in cases where they think they have clear jurisdiction. And I just wanted to add that point. Clear jurisdiction in Austria is something not so clear to many many practitioners, because for example, we had the case of Salesforce, who acquired a company that did not clear the other thresholds, but only were subject to notification according to the idea of the competition authority that if you have 3 different industry reports that tell you something about market shares in Austria, because you have to have a local nexus, then if you have one that tells you have 10% and the other tells you basically not important, will give you clear jurisdiction. So I think one needs to think about that you don't have call-in powers in Austria and Germany, but you have 2 very weird sets of local nexus tests that are differently applied across the 2 jurisdictions, and also one needs to think about the exemptions based on effects, which are also very differently applied across many member states. And I think in the future it will be even more important to think about how the authority would approach a certain case, because I previously practiced in Brussels, and we have this kind of like EU merger control thinking about how national authorities will interpret the statutes that are more or less a copy sometimes of the merger control regulation. But I think one needs to think about that. Europe is a conglomeration of 27 member states with 27 legal traditions that have sometimes a very weird way of interpreting statutes that read alike. So sorry, not really a question, but more a comment.
Clear signs that lunch is